Welcome back to the PI Show. We're here with Martin Smith, a defendant lawyer, and we're discussing before the break the role of a defendant lawyer. Martin, there's what's called deep pocket litigation. Defendant lawyers sometimes, do run cases to verdict. If they lose, then they appeal. And I think tobacco litigation's at one extreme in Australia and in America of what I think is deep pocket litigation.
Yes, as a result of those cases, it's interesting to note in those model litigant guidelines I talked about early, one of the government guidelines is do not take advantage of a claimant who lacks the resource to litigate a legitimate claim. Now, if you're an insurance company or a government agency, you've got a chequebook which is pretty big, as against an injured victim, which is at his own resources. It's frowned upon to take advantage of that, but in that particular case, as you talked about, the tobacco litigation, that went for year after year after year. And the costs of that must have been humongous.
We've experienced that not only in tobacco litigation, but I reckon I see it every day in just your day-to-day work covering transport accident case. When they don't like your client, or they think that there's some issue about liability or there's some issue about credibility, they'll run these cases 10, 12, 15 days. It's just outrageous.
Well, you might think it's outrageous, but I'll put the defendant's hat on and say, no, it's not, because if a person is having their truth serum tested, their credibility tested, they have to prove their case to a court. Never forget that the defendant is not proving the case to the court. The evidence has to be led by the plaintiff. The plaintiff has to prove their case, and if they can't prove their case, they lose. The defendant, on the other hand, has the right there to go to court and test the evidence.
Well, Martin, on that point there, Harry's often said it in the past that, defendant's got to assess his risk.
Yes.
And you can't tell me, and Harry would probably agree with this, that the defendant's not at risk at any percentage level.
I agree with that.
And Harry always sums it up on the basis of, he says, Harry, defendant, 10% risk, 20%, 30%, assess it and make some sort of offer reflecting the risk.
Look, I read somewhere recently that there's no case where there's been no offers made. Often the offer might be each party withdraw bear their own costs.
Well, that's not a real offer, is it?
No, we don't think that's a real offer. But I think there always is some time when matters can be resolved. I think the stats are, in effect, 95% of cases are resolved. 5% go to trial. I agree with Tony. There's some outrageous matters that should be settled, go to trial. It occurs, in my view, where there's a government agency with deep pockets who doesn't care about the costs of a trial and the legal costs, and they just run matters to verdict with no regard to in effect, the risks that are involved. Now,
that's the view, Harry. I'll put the defendant's hat on and say no. The courts these days and negotiations, it's not a case where negotiations haven't been conducted. You would agree that in every case that goes to court, there is a mediation beforehand or an alternative dispute resolution conference. People know where they stand and they understand their risks. There is also a situation where, to add a little bit of spice into the argument, people have the ability to make court offers of compromise or call to bank offers. In other words, people can say to each other, I'm offering you X dollars, if you don't take it, we're going to court.
There's cost penalties associated with that.
So every party should know where they stand before they go in the door.
There's a lot of pressure on a plaintiff lawyer to settle a claim early.
Yes.
Because you've got the client ringing up all the time, they're stressed, they're financially destitute.
Yes.
Their families are breaking up and all sorts of things.
That's another issue, Tony. The delays of justice, I agree with you, is a totally different issue. If there was some way of being able to filter, using your word, Harry, and get the real cases that have to be discussed at court, on court quickly, 6 months after a matter had been issued, rather than go through a 12-month wait and then another 12 months wait, the system would work a lot better.
Well, Martin, I don't think the defendant lawyers are under the same pressure, and quite frankly, more often than not, you get the feeling that they're dragging the chain and deliberately stalling cases.
What, to get more costs?
Well, who knows? Answer that one. Is that what they're doing?
Are they
trying to run up costs, or are they just waiting for the case to come up? Why don't they just meet up with us plaintiff lawyers early?
Look, it's a controversial issue, but I think that can be dealt with by incentivising costs, so that if a matter settles early, because you've used more skilled care and attention, you get paid an appropriate sum for early settlement.
So are you saying that it is a cost issue?
I'm saying it I debate that issue. That's what I'm saying. I think it could be dealt with, that parties are drawn together early and every possibility of settlement negotiations is looked at rather than we are just going to court.
It is a controversial issue. There's no easy answer. I think Tony's philosophy, my philosophy is ring and start discussions early on. We think that's the most productive method.
I commend that proactive approach. I commend it.
As plaintiff lawyers, we like the telephone and we like face-to-face communication.
Yes.
We like to confirm things in writing, but basically we like to talk to.
You want dialogue early, don't you? Don't you really want dialogue early in a piece?
Harry, one of the things you
And-
said there before was that you don't see, the defendant doesn't see the plaintiff. Therefore, you can't assess what's this client like as a witness. I think that's also
Martin,
a controversial issue.
Martin, how many times have I rung up a defendant lawyer and said, look, let's have a conference, I have my client there. You can see my client if you want.
Yes.
But, they don't want to see the client.
And
you know why? There's no
mediations.
empathy.
Yeah.
They don't particularly care. They're acting for a corporation more often than not. And we're acting for real people.
It's an embarrassing situation that you've just talked about. It's nothing worse than going along as a defendant's lawyer and saying, oh yes, I've read the file, my instructions are, and that's the way I'm looking at it. I would have thought, as part and parcel of the settlement negotiations, at least for an opening of a mediation or a conference, a client can be there. They can certainly be taken off into a private room. But the benefit of that is the client actually thinks they've participated from the plaintiff's point of view and from the defendant's point of view. You've actually eyeballed the person. You've actually seen the way they are. You can probably hear something from them if they want to participate. I think that's an advantage, and I don't think it's done enough.
Yeah, well, look, I think they play on the fact that, most plaintiffs are scared to appear in court. Most plaintiffs can't give a lucid account of things. The fear factor kicks in a bit.
Yep.
So, that's a sad thing about the whole system.
Look, they are sad cases. Let's not forget that the majority of cases do settle. Harry, you've harped on that before.
95%.
And so something is working, but I think there is always room for improvement. The test is, how can we improve the system? I believe there's committees working on it all the time. More communication, more dialogue.
More communication.
Yeah.
Well, on that consensus, I suppose we'd like to thank Martin Smith tonight for taking the difficult role of a defendant lawyer. Yes. You'll be with us, I think, next week. You're taking flight, and we're discussing airline cases and airline injuries next week.
Well, Harry's shifted to the good side.
Yeah, well, it's just we're discussing another area of law, and we'll have a break now, and we'll be answering your questions with Viv's mailbag after the break.
Thanks
Thank you.
again.
Thanks.
Thank you.
Thanks.